All right. My name is Laura Rodriguez. I'm the Florida organizer for Jews for Secular Democracy. I'm also one of two state policy advocates in the state of Florida for the National Council of Jewish Women. And we're here tonight to do the You Be the Judge program. So the first part of our program is a little 101 on the federal judiciary. So it might be just a quick review for some of you, and for others, maybe you don't know that much. And then we're going to split up into breakout rooms, and you're going to act as judges and review an actual case, and discuss it amongst yourselves in the breakout room, come to a decision on whether that particular case is constitutional or not, basically, and then we'll all come back together and I will review I will reveal what the actual decision was and give you some information on what happened after that decision was made. I want to also introduce my co-state policy advocate, Pam Gordon, who will be helping me with the breakout rooms. And she's very familiar with the You Be the Judge program as well. Does anybody have any
What?
questions?
Yes.
Yeah. Yes? Does anyone have any questions before we get started?
I just want to note and thank the Bow Foundation for sponsoring, being one of the sponsors of this program.
Great. I'm going to share my screen. Hopefully you can all see this. Let me just. Okay. So this is our You Be the Judge program, which National Council of Jewish Women has put together as part of our Courts Matter program throughout the country. Several states throughout the country have a Courts Matter coalition. Florida is one of them. And if you want more information about any other states, I know we have one in Michigan, we have one in Illinois, one in Louisiana, one in Maine, one in California. They're really all over the place. And we're in coalition with several other groups, including Jews for Secular Democracy. So as you know, the Constitution of the United States spells out what the judicial powers are in our country. In Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior. That during good behavior is the phrase that lets them have lifetime appointments. So we may or may not agree whether they are behaving well or not, but that is the phrase that allows them to have a lifetime appointment. And they shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Article 2, Section 2 states that the president shall nominate and by and with advice and consent of the Senate, shall appoint judges of the Supreme Court and all other officers of the United States. So all those other officers include your Secretary of State, Secretary of Defense, or as they may be calling today, Secretary of War, Homeland Security, all those other people. And you may also remember, you may see some of those hearings on TV where it's very contentious as they go through their nominating process. But that's part of what we're going to go through also. This slide shows you a little bit about the difference between our federal versus our state courts. We have, obviously, as you all know, a U.S. Supreme Court. We have 13 circuit courts, which are courts of appeals. and we have 94 trial courts throughout the country. Most cases are heard in these trial courts. If somebody doesn't like the way it turns out, it goes up to the appeals court, and it only gets to the Supreme Court if it's of major concern for a federal reason and if the Supreme Court will actually take the case. On the state side, it's a similar structure. We have a state Supreme Courts, we have the intermediate courts of appeals, and we have the state trial courts. And dependent upon which state you live in, your judges are either nominated, elected in these different areas of the courts. I can tell you here in Florida that our Supreme Court justices are nominated, are appointed similarly as the president appoints the Supreme Court justices for the United States Supreme Court. Our governor appoints our state Supreme Court justices. They are vetted through what's called the Judicial Nominating Commission. Those commissioners are also appointed by the governor. So it's very important to understand what goes on in your state, because if you follow what I just said, it's very lopsided in the state of Florida, because those commissioners on that judicial commission are appointed by the governor, and then they give the governor nominees for the Supreme Court, and then he appoints those Supreme Court justices. Again, just to highlight the federal system. As I said, there with the appellate courts, these are the different appellate courts throughout our country. We here in Florida are in the 11th Circuit, which includes 3 different states, Alabama, Georgia, and Florida. And you can see on the map wherever you may live, what circuit court you are in. And again, these justices in these courts are nominated and appointed by, they're nominated and the president appoints them. Like, they're federal judges, and they have lifetime appointments. And they make decisions that can last a very, very long time. And so it's important to know who's sitting in those seats. As you look at this pie chart, you might see there's a certain color missing from the amount of cases that are heard in the different courts. That's because so few cases ever make it to the Supreme Court. It has to be a question of constitutionality or something that's going to apply to the entire United States for the Supreme Court to actually take the case. They go through what's called certiorari, and the justices decide whether or not they're going to hear the case. What has happened in recent years, there's something called the shadow docket, and a lot of important decisions are being made in the background. So if you want to hear a Supreme Court debate, you can go to supremecourt.gov and you can listen to court cases being argued in front of the Supreme Court. Often they are those that are very important to the Constitution of our country. However, increasingly over the past number of years, a lot of these very important cases are being decided on this shadow docket, which is behind the scenes, which means they are not being decided and discussed transparently to the public. This pillow just highlights some cases that you may be familiar with that have really shaped our country in the past 40 plus 50 years. A lot of them are very old and are starting to be turned around from recent years. So we go to the nomination process. So the home senators generally are supposed to send names to the White House. So let's say here in Florida, a seat comes open in the 11th district, somebody retired, somebody passed away. The home senators are supposed to send names to the administration and to the White House. In the case of Florida or other states where you have 2 senators who are from the same party, you may have an imbalance of the kind of nominees that they're sending to the administration. The home senators send the names. The administration looks through the names, decide, vets that person, sends them to the president. The president reviews, he makes a nomination, and then that person has to go in front of the Senate Judiciary Committee. This is also the same process whereby we get those officers of the United States, like the Secretary of State, etc. So you may, like I said earlier, like you may have seen a lot of these Senate Judiciary Committee hearings on television where they get very heated and you think, oh, they're never going to pass that person. They sound terrible, etc. But lo and behold, they get passed through and they go through the hearing. The committee votes on the nominee goes through, and then it goes to the full Senate, and they debate on that nominee on the full Senate floor, and then they vote on that nominee. If that nominee gets a full vote, then he or she goes to the president. President says yay, and then we get to watch that person be installed on television with their family, and they put their hand on whatever book they decide to put their hand on, and we're all happy or we're not. This is just to show, it's kind of an older slide, obviously, but it's to show what our coalition is working for throughout the country, that we really want to have the federal judiciary be diverse, be reflective of who lives in the United States, be educated, be committed to the Constitution, and be fair. And those are the kind of nominees that we are really trying to put forward. So you may ask, what can you do? You can contact your senators. As I said, all of these nominees have to go through the Senate Judiciary Committee, and the senators are the ones that put forth the names. If you think a nominee is not reflective of our country, is not showing diversity, is not committed to the Constitution, isn't educated, isn't fair, has shown that their decisions are not based upon facts, or they're not considering the Constitution, you contact your senator. It might seem futile, especially if you're in a state like Florida. However, they do work for us regardless of what party they belong to, and they need to be held accountable. So it's really important to contact your senators when these judicial nominees are going through. Point is, together we all can make a difference. The more noise you make, the more you're heard, and that we're all heard. Now I'm going to ask Pam to come off mute also. And then if anyone has any questions, this was a really brief review because I really wanted everyone to have time to discuss the case that we'll be sharing with you. But if anyone has any questions, I'll open it up. Okay, not seeing any questions. All right, so I am going to, let me see. Sorry, I'm having a little. I'm going to drop in the chat the case that we're going to be reviewing in the breakout groups. This case is called Lund versus Rowan County.
Laura, there is one question before we get to the case.
Okay.
Did you see it in the chat? Is there an
Okay.
easy way to keep track of when people are nominated? And does it happen whenever there's an opening?
Yes, there are. You can go to courtsmatter.org and you will see there's a review of who's nominated for different seats, and you can see how the Courts Matter national coalitions are viewing them, and if they meet those criteria of being educated, being committed to the Constitution, being educated, fair, etc. You can keep track of it that way. It depends. It depends on the administration of how quickly they put forth nominees. If you remember when President Obama was in office at the end of his term, he wanted Merrick Garland, and the other party sort of stopped it from going through. So it kind of depends on who's in power and where they are, but that was a new phenomenon. Usually, as soon as there's an opening, a nominee is put through. All right. I dropped in the chat the case. I just want to make sure that everybody can open it because you're going to be wanting to read through it. This case has to do with in North Carolina with a government committee using invocations before they began their meetings, and whether or not it violated the Establishment Clause in the Constitution.
Laura, I can see that not everybody's on it. Do we want to do maybe a quick screen share and just you review the quick basics of it in case everyone can't click on there?
Or, um,
I can actually screen share it too.
I got it.
Got it. Okay.
I think I got it. All right, can everybody see?
Yep.
All right. So I'll let Pam read some of it.
Do you want me to start at the beginning?
Yeah, just start reading it.
Okay, because already I'm getting mad at this whole thing reading it. It's just, if you're a secular humanist, this doesn't work. The Rowan County, North Carolina, the County Board of Commissioners, the board, holds 2 public meetings per month. County residents elect 5 commissioners to the board, and the county exercises governmental powers through the board. Nancy Lund is one of the several residents of the county who regularly attends the board meetings. A commissioner begins each meeting with an invocation of their choosing. The 5 elected commissioners deliver invocations on a rotating basis. Attendees are directed to stand for the invocation. Board members nearly always bow their heads during the invocation, which usually starts with the phrase, "Let us pray," or "Please pray with me." Of the 143 board meeting invocations that took place from November 2007 to March 2013, 139 invoked Christianity and included references to Jesus the Savior and other tenets of the Christian faith. Those that did not invoke Christianity did not invoke any other specific faith. Do you want me to keep going?
Yeah, keep going.
In February 2012, the ACLU of North Carolina Legal Foundation sent the board a letter explaining that the sectarian nature of the invocations violated the First Amendment of the Constitution based on then existing precedent. The letter requested a response from the board. The board did not formally respond, but several individual commissioners made public statements, including one on local TV news, that he will continue to pray in Jesus' name. Another commissioner publicly stated, "I am sick of tired of being told by the religious minority what's best for the majority. My friends, we've come a long way, the wrong way. We call evil good and good evil. By March 2013, the invocations had not ceased, and Lund and several other county residents initiated a lawsuit in federal district court alleging that the county violated the Establishment Clause by delivering sectarian legislative prayers and by forcing plaintiffs to participate in religious exercises. Plaintiffs stated that they felt coerced by the prayer practice. Nancy Lund stated that she felt compelled to stand so that she would not stand out. Plaintiffs stated that the invocations made them feel excluded from their community and the local political process, and that the practice sent a message that the county favors Christians. One plaintiff had previously proposed a non-sectarian prayer as an alternative to the existing invocation, but it was rejected. That individual expressed concern that he was no longer considered a credible advocate in the county. The county claims that anyone may leave the room during the prayers and that doing so would not impact his or her right to participate in the meetings. The county has no written policy regarding its legislative prayer practice, but claims the practice is part of a long-standing tradition. It insists that the invocation is given for the benefit of the board itself in order to solemnize the meetings. Relevant law. The Establishment Clause of the First Amendment to the U.S. Constitution states in part, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In Town of Greece versus Galloway, 134 South Court, 1811, which is from 2014, the U.S. Supreme Court held open town board meetings with prayer offered by members of the clergy does not violate the Establishment Clause when the practice is consistent with the tradition long followed by Congress and state legislatures. The town does not discriminate against minority faiths in determining who may offer a prayer, and the prayer does not coerce participation with non-adherents. The legal question: in light of all the facts, does the county's policy of beginning each board meeting with a prayer violate the Constitution's Establishment Clause?
Thank you, Pam.
Yeah, that's what we're going to be working on.
Thank you. So I just want to, I need to get to another document. So we're going to discuss this. I'm going to, I just want you to consider, I want everybody to try to participate. You're all considered a judge right now. And everybody can discuss, this, what they think about this particular case. And just some questions to think about besides the overall legal question, which Pam read, is, do you think that the board's prayer practice constituted coercion? Would you feel comfortable walking out of a meeting during the prayer? Have you done or seen anyone do this? What was it like? Do you think you'd be taken seriously as a town advocate if you left or sat down during the prayer? Would your answers change if this case involved young students, not adults? And do you think the board's prayer practice promoted one religion over another? Do you think it matters that only the commissioners delivered prayers? Okay, case reveal. The U.S. District Court for the Middle District of North Carolina. At the district court level, the judge noted that an Establishment Clause analysis is inherently fact-intensive and requires a thorough examination of all relevant details. Courts must take into consideration any social factors and all unique circumstances. The district court relied heavily on the Supreme Court's recent decision in Town of Greece versus Galloway and noted at the outset that any legislative prayer practice with a pattern of denigration or proselytization would not withstand a constitutional analysis. The legislative prayer practice must fit within this nation's long-standing tradition of legislative prayer in a manner that does not over time have the effect of promoting or disparaging any given religion, and instead unites lawmakers in moments of solemnity. The district court began its analysis by noting that all board meeting invocations were delivered by commissioners themselves in accordance with his or her respective faith, as opposed to a diverse group of outside clergy, as was the case in Town of Greece. The court found that by creating a closed universe of prayer givers, inherently excluding any faith not held by a commissioner, and by allowing the commissioners to be so intimately involved with invocation, the prayers were effectively being delivered by the government itself. The district court went on to reject the county argument that the invocation is solely for the benefit of the board, and found that the board's requests for the public to join in the prayer were coercive. The district court noted that at no point were county residents made aware that they could leave the room during the invocation as suggested by the county. Moreover, an invitation to participate issued by a government authority often carries more weight than an expectation of compliance than other invitations. Thus, those who did not participate were essentially deemed outsiders, not full members of the political community. Lastly, the fact-intensive analysis required the district court to examine the context in which the prayer occurred and the character of the prayer itself. Because the prayers were delivered in the context of a government meeting by elected policy-making officials, and because the requests for public participation forced politically minded county residents to either acquiesce or brand themselves as outsiders, the district court found the practice to be unconstitutionally coercive. For the foregoing reasons, the district court held that the county's prayer practice violated the Establishment Clause based on the Supreme Court's ruling in Town of Greece, Lund v. Rowan County. Fourth Circuit, it went to the Fourth Circuit Court of Appeals. The majority of the Fourth Circuit Court panel reversed the district court decision. So it went to the Court of Appeals, and they just used a panel of judges. It wasn't a full bank of judges that reviewed it. So the majority of the Fourth Circuit Court panel reversed the district court decision. Based on the precedent set by Town of Greece and previous cases, the majority found the county's prayer practice to be constitutional under the Establishment Clause because it falls within the county's recognized tradition and does not coerce participation by non-adherents. Contrary to the district court, the majority found it insignificant that the invocations are delivered solely by commissioners, arguing that the lower court decision has the practical effect of imposing a bright-line prohibition on lawmaker-led prayer. The circuit court emphasized the historic practice and acceptance of legislative and lawmaker-led prayer. It went on to agree with the county's assertion that the invocations are largely for the benefit of the lawmakers themselves, who may find that at a moment of prayer sets the mind to a higher purpose and thereby eases the task of governing. Furthermore, the circuit court warned that rejection of a sectarian prayer by a legislative body amounts to governmental censorship of religious speech, thereby leading to more government involvement in religious matters. The circuit court also found that the specific invocations in question contain sufficiently universal themes, such as giving thanks and requesting divine guidance, though it noted that references to exclusively Christian concepts, such as in Jesus' name, were present. Nonetheless, these references did not amount to proselytization, according to the majority, as they did not strongly disparage other religious views or outwardly seek religious conversion. Lastly, the circuit court found that the prayer practice was not at all coercive. Adults, the majority noted, are not presumed susceptible to religious indoctrination or pressure simply from speech they would rather not hear. The circuit court noted a lack of evidence in the record that suggested any adverse consequences to those who did not participate in the prayer, confirming its findings that coercion did not exist. The district court's ruling was reversed. Pam, you want to read? I'm getting a sore throat.
Yeah. The dissenting opinion. One judge on the 3-judge panel dissented from the ruling, reiterating that Establishment Clause analysis are fact-intensive and noting that these particular circumstances go beyond constitutional limits. According to the dissent, this unique combination of legislative prayer givers exclusively of one faith, legislative invitation to the citizens before them to participate, and exclusively sectarian prayers referencing a single faith in every regular meeting of a local governing body over a period of many years rises to the level of coercion that Town of Greece condemned. I agree with that guy.
Okay, does anybody have this? This isn't the end of the story. If anybody has any comments so far, any thoughts? There is more to the story, and I'm going to share what happened next. And I'm going to let Pam read this one.
Okay, what happened next? Have there been any further developments in the case? Yes. Following its 2016 panel decision, the Fourth Circuit Court of Appeals agreed to rehear the case in bank, meaning that all judges of the Fourth Circuit Court would hear and rule on the case. In a 10-5 ruling decided July 14th, 2017, the full Fourth Circuit affirmed the judgment of the district court, finding Rowan County's prayer practice unconstitutional. The court held that Rowan County's practice, which served to identify the local government with Christianity and only allowed commissioners to deliver prayers, extended far beyond the clergy, led practice allowed by Town of Greece versus Galloway. The court wrote that the great promise of the Establishment Clause is not that religion will not operate as an instrument of division in our nation, and concluded that Rowan County could easily incorporate more inclusive forms of opening prayer into its public sessions. On October 12th, 2017, Rowan County filed a petition for a writ of, okay, who's an attorney that knows that one?
Certiorari.
Okay, thank you.
I'm
Which
not
is
an attorney, but
okay, which is a formal request to the U.S. Supreme Court to accept and hear the case. In June of 2018, the Supreme Court denied the writ of certiorari, meaning that it would not hear the case and that the en banc ruling of the Fourth Circuit would stand. So we won one of them.
Right. So that case ended up as most of us would have wanted it to end up.
I think cases involving religion are real sticky right now.
That was a real roller coaster ride. Thank you, Laura. I appreciated the drama.
All right. Thank you all so much for joining us. I hope that you enjoyed the conversation and that you learned a little bit of something, refresher course, and that you can accept or you can appreciate the headaches that judges may have.
And I am going to say good night to everybody and let everyone go. I do want to ask everyone, anyone, since the people coming to this call are active, to remind everyone we have our next call with us. Information is going to be going out in a couple days. We are going to do the John Lewis Every Child Deserves a Family Act, which is in support of LGBTQ plus families and children. There's a link in the chat, but you'll also get an email from me. So we would love to have you join us for the next call with us. And Laura, I just want to thank you and Pam for running this.
Thank you for helping me, Pam.
It was amazing.
I love
Thank you
this
very much.
Very
Thank
interesting. Thank
you. Have a good night, everyone.